Welcome everyone to another edition of the Practical Adjuster brought to you by FreeClaimInfo.com. My name is Jerry Adair. Today we're going to be discussing the topic of understanding liability claims. Today we're going to talk about understanding liability claims. And that seems like a complicated endeavor to some people, but it's primarily because they've never had someone start at the beginning and explain to them how liability works, how it's applied in a claim circumstance. They think they know it, and then they get into the middle of something and they don't really understand all the terminology, the variables, and they get confused. So we're going to try to break it down so you can understand it, where the next one that comes along, you're going to be able to adjust that claim with confidence. So we're going to use as our reference a book that I still use to this day. I've had it for probably over a decade. It's called Casualty Claim Practice. I think it's the 5th edition. It's written by Donald Hirsch and James Donaldson. So I would suggest if you want to get a book, which is a great reference tool, that's the one I would refer you to. It's not a book you're going to read through and learn everything. It's a book that you can browse through. You can look at topics and find those topics in that book. When you have a circumstance come up, you're not sure about it, go to that book, look it up. It's a great tool. I highly recommend it. So today we're going to start talking about torts. That's the very beginning to get you into liability claims. Now, it seems like a term that most people wouldn't know what it is, particularly if you don't do liability claims, but all it means is a wrongful act that includes some other provisions. So any wrongful act that includes these provisions can result in an action or a claim or a lawsuit, if you want to use that term. But a wrongful act is just something you did wrong. But to be a tort, an actionable tort, it must involve some of the following. It must involve a violation of a legally protected right. And those rights would be common law rights, or the laws or the precedents established by court cases and rulings, precedents, okay? The next one would be statutory law. So those laws passed by our legislatures, state, federal level, those kind of laws, a violation of one of those. Now, the wrongful invasion must be a violation of one of those rights, okay? The next part is that violation of one of those protected rights must result in damages that are the proximate result of that wrongful act. So if you have to connect all that together, you must have a wrongful act that violates some laws or some protection or rights that we already have, and that it causes damages that directly result from that wrongful act committed. If you have those, you have a tort. Now that we've explained what a tort is, we're going to talk about the different types of torts. There are 3 primary types of torts we're going to explain. The first one is intentional. That's exactly what it sounds. You intentionally commit an act to harm somebody. We're not going to spend a lot of time on that because insurance companies exclude intentional acts. So if you intentionally go out to harm somebody, don't expect your insurance company to bail you out. It's not going to happen. All right. The other one we're not going to spend a lot of time on is strict liability. And that's a circumstance that either by the common law or courts deciding this environment is so hazardous and so dangerous that liability can be impugned just by the near regular operations of that place. A nuclear power plant might be an example. The other one would be statutory, where they decide that a plane, for example, shouldn't be falling out of the sky. And if it does, there's liability. Those are 2 examples that you might find that are strict liability. We're going to focus on the second one, which is negligence. And negligence is just a mistake or a harmful act that is caused or that you allow to happen by mistake. You didn't intend for someone to be injured. It happened. You injured somebody. It's a negligent act. And that's what we're going to focus on today, because that's the primary things you're going to run into on liability claims. All right, now we're going to discuss what is negligence, okay? Negligence is defined as a failure to exercise reasonable care as the law requires. And for a tort action to result, the following must be included in that failure to exercise reasonable care. There must be a legal duty owed that preceded that act. There must be a failure to comply with that law. There must be a causal relationship between the act and the injury or the damages, and the damages must be a proximate result of that negligence or that wrongful act. If those are present, then you got a negligence circumstance. All right, now what are some examples of tort actions or torts that can result in action. An example might be an automobile accident where someone commits a wrongful act by disregarding a traffic signal. That would be the most common example, probably. Another one would be someone becoming or being injured on your premises or on the premises of a business owner or residence. And there could be a tort depending on the circumstances of what led to that injury. The next one that will be a primary focus would be probably contractor errors. You have a plumber that does some repairs to your home, and in the process, they do something which allows water to spill into your home unexpectedly, causing damage to your premises. That will be another action of a wrongful act that results in a tort action. Now that you understand what negligence is, there are different types of negligence. And in order to know which one is applicable to your claim environment, you'll need to first know the state where it occurred, and what that state determines is their standard relating to negligence. There are two primary types of negligence we're going to talk about today. The first is contributory negligence. And that one is by and large obsolete in most places, but not entirely. Last I saw, Alabama might be one of the remaining states that uses that as part of their statutory law. There might be other states that I'm not familiar with that do, but I don't think there are a lot. But you need to become familiar with a state where this claim occurred and learn what is their law related to negligence. But if it's contributory negligence uses this theory that everybody must use reasonable care. And there's a doctrine called the last clear chance doctrine, which means if you have an opportunity to avoid an act which is going to cause damages, you must take that option and exercise it. A good example of that will be in an automobile accident. Someone pulls out in front of you, you don't have the right to continue on running into that person because they pulled into your path. The law says, no, you have an opportunity to avoid that accident by stopping or swerving to avoid it. You're supposed to exercise that. And if you don't, then you're also guilty of negligence. Now, in contributory negligence, the law basically says if you contribute to the accident in some way, you can be barred from recovery. So you can have one person who's maybe 90% at fault causing the accident, and you are 10% at fault. Under contributory negligence law, both parties can be barred from recovering from the other. So they both contributed to the accident, therefore neither can recover. Now, there are some variables in terms of whether those acts were slight negligence or gross negligence. Sometimes they'll use the term casual or remote negligence. In other words, you did something wrong, but it really didn't result in the proximate cause of the accident. It was so minute that it really didn't have a bearing on the causation. That might be something which would help and not have your claim, your damages where they were prohibited or barred from recovery because the negligence that you committed was so remote or minor. Okay, but that would be the only circumstance. But by and large, if you contribute to the accident, you can't recover from anyone, either party. The more common term of negligence you're going to find, or the law, is comparative negligence. Comparative negligence has provisions that go with it. One would be treating it as a pure form of comparative negligence, and the other as a modified form. The pure form basically says that each party in an incident that contributes to the accident can only recover for the degree of negligence by the other party. So if you have an accident where two people are 50% responsible, that's pretty easy. They each get 50% of their damages because they were both 50% responsible. On the other hand, if you have one party who is 75% and the other one 25%, then their shares are reduced or increased depending on the nature of the negligence. So the party who was 75% responsible can collect no more than 25% of his or her damages. Okay, the other party who is 25% responsible can collect no more than 75% of their damages. So it's a purest form of comparative negligence. Each side gets a prorated share if you want to review it that way. Now, there is also a modified form of the comparative negligence law, and it's going to have a few variables But by and large, the modified form is the same as the pure form, except that it does bar recovery for some people. And generally, the threshold is 50%. So, for example, if the threshold is 50%, the law might say if you're 50% or 51% or more negligent in causing this incident, then you're barred from recovering anything. The party who is 49% or less responsible can collect their damages from the party who is more responsible. So it's the same thing except one side gets barred. So it's sort of a cross between contributory and comparative. But it can vary. The amount in terms of the threshold can be 49%. If you're above 49%, you're barred. 50, maybe 51% I've seen in some jurisdictions. So it depends on how the statute is written in that state in terms of how you define that. But that's generally what it means. You just have one side that gets barred from recovery. The other side can recover what they need to recover for the damages caused to them. Now that we've established what negligence is, the next part is understanding how you determine or who determines negligence. And one of the things that comes up often is a person will say, well, you're at fault for blah, blah, blah. Well, the law says in order for you to assert a claim or an allegation of negligence that results in a claim or a cause of action, the burden of proof is on you. So you being whoever is presenting the claim. So if we're talking about an incident where there's a claimant alleging that our insured did something wrong, well, our response is always, what's your proof? You have to prove it. Now, we always do our job, try and help if we can. So we ask for their cooperation. That's why you take statements. Maybe you take photographs. You do scene investigations. You interview all kinds of people. There are police reports. You get police reports. There are you get medical reports to help document the nature of injuries, and sometimes that will help establish causation and things of that nature. But the bottom line is, the person who's presenting the claim, it's their burden. And if they can't prove it, then our insured, and you on behalf of our insured, don't have to prove anything. So I've had many instances where I've investigated things and I thought, well, maybe there's a possibility that our insured was negligent, but there's no proof of that. It's just an allegation. So without any proof, there is no claim. And you can feel confident in telling someone that if they can't prove it by virtue of whatever they can provide to you in terms of statements, photographs, evidence in another manner, if they can't prove it, then you don't have to do anything. And you don't necessarily deny claims. You refuse to accept liability if there is insufficient proof to document it. That's what you're looking for. You're looking for sufficient proof to determine with a reasonable certainty that our insured was negligent of whatever it is that the allegation has been made against them. And if there is insufficient proof of that, then there's nothing else for you to do. You don't have to prove beyond a reasonable doubt that your insured didn't do something. It's the other way around. They have to prove beyond a reasonable doubt or beyond the term is not the same as a criminal situation, but beyond a reasonable certainty that our insured did something that caused these damages or this injury. So that's what you're looking for, and that's why you're asking the claimant to cooperate so they can participate in this process. If they refuse to participate, then it makes the job of proving negligence very, very difficult on their part or an attorney representing them in a circumstance. Now, it's important to understand that when you're dealing with liability claims, while there's always an idea that somebody is responsible for an accident, therefore somebody must pay, that's not the way it always works. There's one element which is called assumption of risk. An assumption of risk is, generally speaking, an idea that if you enter into a circumstance with an idea that you're likely to be injured, or the circumstance you enter into voluntarily is so hazardous that most people would say, well, you knew what was about to happen. You knew you were likely to be injured in that circumstance. And if that happens, the courts can determine that you're barred from recovery because you assumed a risk. An example might be getting into a car with a drunk driver. You should have an idea that that person is intoxicated. If it's so obvious you knew it, then you can't sit back and then later say, I'm shocked that they ran off the road and lost control. They had drinks all night long, but I had no idea they were going to lose control. That argument doesn't wash. And the courts have said If you assume a risk in a circumstance, you may be barred from recovery. Now, it needs to be established that they did know the risk they were getting into. There are a host of variables, but that's generally what the statute is talking about, is somebody that gets into an obviously hazardous situation and then becomes injured in the process. Now, the general idea when you're trying to evaluate a liability claim is that the accident must be avoidable, or the incident, if we're talking about a premises incident or something of that nature. But the circumstance which caused this wrongful act we've talked about, what caused these injuries, it must have been avoidable or preventable, okay? And that means that the person who committed the wrongful act did something wrong. There was a way they could have prevented this from occurring, and they didn't. And that's why they're negligent. So you're going to occasionally, and I've run into this one time in my long career, where there's an accident, by the way, a car accident that was unavoidable. And it can be usually in one of two ways. It's either going to be a medical emergency occurred. For example, a person has a heart attack out of the blue, or a stroke. And when they had this stroke, they of course lost control and caused a collision, and people were injured, okay? But it wasn't that person made a mistake to have that stroke. They were as much a victim as anyone. They weren't negligent in having a stroke. We have another one where a mechanical issue occurred, that the person, their part of their mechanical system that affected their brakes broke. They had no prior notice of it. They didn't neglect to maintain the car. It was nothing that they could have foreseen or prevented. If they had known that they had brake problems and neglected to repair those, that wouldn't be the same thing. They knew they were having brakes that were starting to go bad, and they just didn't bother to get them fixed, hadn't gotten around to it yet. That's not a mechanical emergency. So we're talking about a circumstance where you, as the adjuster, cannot find any circumstance which leads you to conclude that person knew they were about to have this issue occur, that they had any way of preventing it. If you think they could have done either of those things, then they've got liability potential. But we're talking about where you search and you can't find any idea that they, or any evidence that they knew they were about to be in this circumstance, or there was about to be a problem, there was something they could have prevented, and they just didn't take the action. If there's not that environment where they couldn't have prevented it, it was an unavoidable accident, then that person is probably not liable. And that may be an accident you have, which I had one in my career, where it was a serious accident, but there was no liability found on either driver. It just happened. Now that you've finished your investigation, let's say you've come to the idea that your insurer was negligent, you have some liability. So you need to take that and use that to resolve the claim. So you've got to establish their damages and the proper way to measure those damages. So whether you're referring to an automobile accident and vehicle damage and personal injuries, or maybe you're talking about the contractor did some damage to somebody's house, a plumbing line broke that they repaired, water flooded the house, or maybe you're talking about someone who slipped and fell and injured themselves on the premises. Any of those circumstances, the same principles for measuring damages are going to apply. So you're going to have those broken down into two categories. The first is bodily injury, and second is property damage. Now, property is a wide term. It doesn't just mean a piece of property, but it basically means anything which is not part of the bodily injury claim. So you're going to have the bodily injury claim, which is medical bills, lost wages, and compensation for pain and suffering. Anything else is going to be considered property damage, whether it's the vehicle, whether it's their personal computer in the car, some clothes they had that were damaged, their house, carpeting, furniture, anything you can imagine, cameras, whatever. If it's not part of the bodily injury, it's considered property damage. Now, so in property damage claims, the evaluation, you have some guidelines, although it's a little bit of a gray area like everything in liability claims. But the legal terminology for how you define a property damage claim is called the difference between the before and after value. So an example might be in an automobile accident. The vehicle in the accident, before the accident, let's say it's worth $20,000, okay? You have a collision, it gets damaged. And immediately after the accident, its condition is determined to be worth $5,000. It's wrecked condition, okay? So the difference between those two, or $15,000, that would be the measure of that property damage claim. How you get to that point is another gray area. You can use a body shop estimate. You can have an appraiser look at it. You can come to a negotiated amount with the owner of the vehicle to evaluate those damages, which are going to include the repair cost, the car rental or loss of use allowance, any diminution of value for a vehicle that's been determined during the course of that wreck. The damage caused it to be worth something less than it was before, even in a repaired condition. You can have a whole host of issues go into that to get to that point. But the bottom line, when you get through putting all that together, you should be considering, is this relevant, or is this fair in terms of the before and after value difference? And if it is, then that's a good settlement amount. If it's not, maybe you need to take a second look at it. You wouldn't pay $30,000 to repair a vehicle that was only worth $20,000. That wouldn't be a fair representation. Okay, so you would have a total loss value, and then the insurance company, or you on behalf of them representing our insured, will get the salvage value to dispose of to get part of the money back. In all those circumstances, you come right back to what we define as the difference in the before and after value. So it can be a little confusing, but if you'll keep that idea in mind that we're trying to get to a number that represents the difference between the before and the after value, that's what you're trying to get to. That's how you measure those damages. And keep in mind that this is not like a policy claim where you have replacement cost coverage. There is no replacement cost valuation in terms of liability claims, ever. Doesn't exist. Policies don't matter in terms of this. We're talking about damages, statutory defined damages. So if you're talking about someone's car, the value of that car would be what that car is worth. If it's a 2-year-old car, it's a 2-year-old car with a 2-year-old car value. They don't get the benefit of what a newer model of the same thing would be worth, or a car in much better condition than theirs was in. On someone's house, which is damaged, there are depreciated items on there. There's new carpet to be replaced. They had 2-year-old carpet. They're not entitled to be compensated for brand new carpet. They had 2-year-old carpet. So you depreciate that to get to that value number. Use that for any item that we're talking about. A computer, a pair of pants, it doesn't really matter. Any item that has a set value or a set lifetime, it's not worth the same thing when it's 2 years old that it was worth when it was new. So in a liability claim, establishing the value of that piece of property, you want the value of it at the time of the incident, less any remaining value that it might have. So don't get caught up in that and thinking, well, they didn't cause this, and therefore they're entitled to get it all repaired at no cost to them. That's hogwash. That's not the way liability works. Now, there is some give and take, but you want to keep in mind that your job is to make sure that you're being fair and equitable to both sides, not just to the claimant, but to the other side. You shouldn't be asking an insured or insurance carrier to pay more than what's due that injured party. That's your job. Now, when you're getting into bodily injury claims, they're not as easy to define. You're going to have medical expenses, but then you have the variable of, is it the cost that the hospital charged on the initial statement, or is it the adjusted amount that the hospital reduced the charges to once they found out this person had health insurance or that they had Medicare, or things of that nature. That's a gray area. You're going to have to look at the statutory things for your jurisdiction and see what works for you. It may be a gray area that you have to do a compromise between you and the claimant, okay? Same thing with lost wages. They were off work and they didn't get paid, they have lost wages. What if they're off work and they continue to get paid? They really didn't sustain a loss. Now, you'll have plaintiff attorneys try to argue they lost work and they should be compensated, but I always argue differently. Again, that's an issue you're going to have to address in the area where you live to determine what's appropriate and what the insurance carrier involved wants to pay. But it is a gray area. There's not a cut and dried rule that says you must do this or you must do that, okay? Compensation or compensatory damages, those are always subjective. And they're a consideration based on the type of injury a person incurs, whether it's a full recovery or something less than a full recovery, the duration of the treatment, whether they go and visit a doctor once or twice, or do they have to go to a doctor for 6 months and then do 6 months physical therapy, that kind of stuff. They have to make multiple trips back and forth to the doctor and things of that nature. It might extend or increase the value. So there are a host of issues, and that's not something we can talk about in a 2 or 3 minute video here. that's going to take some skill and some experience to kind of come to an understanding of how you evaluate those. It basically comes down to experience and understanding the level of injury, the level of incurred expenses, the level of recovery, and all those kind of attributes. And then it even becomes more variable depending on the condition of that person. Are they a 20-year-old in really good condition? Are they an 80-year-old who is already in bad condition and is hurt much more by a fall than a 20-year-old would be? So there are a host of variables there that you'll have to consider when you're evaluating that claim. Well, this concludes our video for the assessment of liability. I hope you found it to be interesting. And if so, please share this video with anyone you can, anywhere you can. We'd also appreciate you liking it on YouTube. For other information, I would suggest you check out FreeClaimInfo.com. There you'll find guides, documents, and other tools to assist you in your claim. There's also a message post on each video, which will be on the message board, where you can post questions, or other people have posted questions, and you can look at the answers there. Or if you have a different question, post it, and someone with Free Claim Info or in our claim community would try to assist you. Thanks, and have a great day.